Did the U.S. hand a foreign leader over to prosecutors after a night raid across an ocean and then use secrets from spycraft to put him on trial in Manhattan? What counts as usable evidence when evidence is gathered in a jungle or from a drone halfway around the world? Stay with me. By the end of this episode, you'll know the courtroom playbook judges and lawyers use to decide what survives in U.S. federal court after an extraterritorial military or covert operation. This is a Courtroom Files explainer, step by step, how U.S. courts decide whether evidence from overseas raids or secret operations is admitted at trial. We'll walk through the constitutional tests, the paperwork that makes or breaks physical and digital evidence, the special procedures for classified material, CIPA and FISA section 1806, and practical strategies both sides use. I'll use real, recent examples from January 2026 reporting about the U.S. operation to seize Venezuelan President Nicolas Maduro, often called Operation Absolute Resolve, to show how theory meets practice. Quick disclaimer before we dig in, this is educational content only. It explains legal doctrines and procedures. It is not legal advice. For case-specific questions, consult a licensed attorney. Start with the jurisdictional baseline. The surprising historic rule is blunt. Forcible abduction alone usually doesn't bar trial in U.S. courts. That comes from Kerr v. Illinois in 1886 and was reaffirmed in United States v. 18, Alvarez-Machain in 1992. In Alvarez-Machain, the Supreme Court held that a forcible extraterritorial abduction did not automatically deprive U.S. courts of jurisdiction. Sounds raw and unfair, right? But here's the twist. Courts separate the question of jurisdiction from the remedies for illegal conduct. So even if a capture violated a treaty or international law, the defendant may still be tried. The remedy might be diplomatic, not necessarily exclusion of evidence. But here's where it gets interesting and thorny. What if the capture was ordered by the executive branch and justified in classified memos? In January 2026 reporting, the Justice Department Office of Legal Counsel produced a memo justifying the Maduro operation and said it was unnecessary to resolve whether the seizure violated international law. That public posture matters in court because judges will often avoid sweeping international law rulings unless they have to. So the first box judges check. Is there jurisdiction, or does the abduction itself destroy the court's power? Usually the answer is no, but the case rarely ends there. Next question, do U.S. constitutional protections apply to evidence collected overseas? The answer is fact-specific. The key case here is Verdugo-Urquidez, where the court limited the Fourth Amendment's reach for searches abroad, especially regarding non-U.S. persons in territory. Courts ask whether the victim of the search had a sufficient connection to the United States. For detained foreign nationals seized abroad, many circuits have treated protections as limited but not non-existent. The result? Suppression motions under the Fourth Amendment succeed less often when evidence is gathered outside U.S. soil. Now imagine the government says, "We used intelligence intercepts from abroad to locate the target," while the defense replies, "Those intercepts were illegal, suppress them." What happens? The judge has to sort constitutional law, classified procedures, and practical fairness, often through in-camera review. Judges prefer surgical remedies, redacting or segregating the contested intelligence rather than throwing out the whole case. Here's the most practical battlefield: chain of custody and forensic integrity. Whether physical evidence, a hard drive, or a biometric sample, what matters in federal court is documented custody, validated forensic methods, and preserved metadata. Courts routinely exclude or limit items where logs are inconsistent, timestamps altered, or handling breaks occur. Ask yourself, would you trust a lab result with missing timestamps? Neither will a jury. That's why prosecutors, especially after a high-profile military operation like the Maduro seizure, double down on documentary proof, custody logs, photos, SHA, 256 hashes for digital files, and independent forensic testing. Defenses attack those gaps relentlessly because it's often the clearest path to exclusion. Often evidence from the operation that survives at trial is not the raw, unvouched intelligence. It's the independently collected physical or digital evidence with a clean chain of custody. After the 3rd of January 2026, press reporting noted a mix of evidence types, captured devices, recorded statements, and financial records in courts will treat each on its own merits. Pattern interrupt. Imagine the crown jewel of the prosecution is a classified intercept no one can see. How does a judge weigh it? Enter CIPA, the Classified Information Procedures Act. CIPA gives a step-by-step procedural path. The government can seek in-camera hearings, propose redactions, offer substitutions or summaries, and ask for protective orders. The judge reviews classified materials privately and decides what, if anything, the defense needs to see to mount a fair defense. This is crucial. CIPA is not a magic cloak that lets the government hide everything. Courts must still ensure the defendant's Sixth Amendment confrontation rights and ability to challenge evidence. But the balance often tilts toward limiting disclosure to the minimally necessary material. In recent high-profile filings, including those tied to the January 2026 operation, prosecutors typically invoke CIPA early, signaling judges that classified issues will play a big role and that in-camera procedures will control the flow of evidence. Don't confuse CIPA with FISA procedures. When the government's evidence derives from foreign intelligence electronic surveillance under FISA, Section 1806 comes into play. Section 1806 permits in-camera, ex parte review of FISA-derived materials to decide suppression motions. The defense will rarely see the underlying FISA application unless the judge concludes disclosure is necessary to assess legality. But here's the catch. Courts have wrestled with whether the state secrets privilege can override Section 1806 procedures. Case law suggests Section 1806 often governs, meaning judges do private review and disclosure to defense remains the exception, not the rule. In practice, prosecutors will assert FISA or Section 702 collection cautiously because invoking that regime shifts the case into very limited judge-controlled review. Now imagine a recording from abroad. Is it hearsay? Is it testimonial under the Confrontation Clause? Courts parse these questions carefully. Statements that are testimonial require confrontation, live testimony, or acceptable exceptions. But many foreign statements fall into non-testimonial hearsay exemptions or are offered under the business records or other federal hearsay exceptions. Authentication matters doubly when foreign law is involved. Judges want foundation, translators, chain of custody for translations, and sometimes mutual legal assistance treaty channels to verify documents from foreign governments. Coerced statements raise due process concerns and may be suppressed if the defense can credibly show coercion, though the evidentiary showing can be steep when the events happened abroad. What about detained foreign nationals? Protections vary. Many circuits give limited constitutional protections to non-U.S. persons seized overseas, but defendants still can make coercion, due process, or voluntariness claims and can press treaty-based or international law arguments as facts that influence remedies. So what do prosecutors actually do in practice? After the 3rd of January 2026 operation, prosecutorial strategy based on prior patterns is predictable. Compartmentalize the intelligence, use CIPA or Section 1806 to litigate classified material quietly and build a case around independently verifiable domestic evidence like seized devices, financial records, or cooperating witnesses. For defenders, the practical checklist is also clear. Attack, chain of custody, demand, Section 1806 or CIPA review when FISA or classified materials are invoked, pursue Frank's motions to challenge warrant affidavits, and aggressively litigate voluntariness and coercion claims. So after all these layers, international law, constitutional tests, CIPA and FISA, chain of custody, hearsay, what actually survives in court? Don't skip the recap. Quick summary. Jurisdiction usually survives forcible abduction. Kerr and Alvarez-Machain are key. Constitutional protections have limited extraterritorial reach, so suppression claims succeed less often for overseas searches. Chain of custody and forensic integrity are decisive for physical and digital evidence.